I'm back. I want to talk about the beginning when you get served a child support summons. In the beginning, this is where a lot of y'all mess up at. Okay, before I get started, y'all go ahead and hit the like button, please. Hit the like button. You know, if you haven't subscribed yet, go ahead and do so. I want to go and get that out of the way so I won't have to remember to say it at the end. I want to go ahead and go in. Okay. I do appreciate it, y'all. Let's get it started. I want to start with, in all cases, so you got served a summons where I'm talking specifically to dudes. Put to dudes mainly because dudes are the ones getting their ass handed to them in family court. So you ladies who are watching this, you know, don't feel hit or whatever if I'm talking, I sound like I'm talking to the guys and only the guys, but I'm talking to women who are actually on child support or fighting any kind of, you know, you're in the same situation that men generally go through. Okay, so just work with me. Fellas, you get a child support summons. This is what most of y'all mess up at when y'all get a child support summons. It says, in all cases where a plaintiff files a pleading with an affidavit attached to the effect that the facts stated in the pleading are true to the best of his knowledge and belief, the defendant shall in like manner verify any answer. Most of the time when y'all receive a summons in court, a child support summons, you don't verify an answer. Keep in mind the key word is verify. Follow me when I say verify means that I'll show you what it means to verify. Okay, but right here, this is basically what they did. They had a plaintiff and they said attached. They said with an attached affidavit, with an affidavit attached to the plaintiff, to the complaint. They have an affidavit supporting what it is that they're saying that you did wrong or whatever it is they're trying to get done. Okay, they have an affidavit. Remember, only a living man or woman can actually do an affidavit. So this is where this is sort of like they're creating a separation between the man and the woman or whatever. However they're doing it. Bottom line is they scratch that statement. Bottom line is they're actually verifying their complaint with an affidavit. Okay, you were supposed to do the same damn thing when you got one. Instead, you just got nervous and be like, man, I got caught on the such and such date or the such and such month. Man, she trying to put me on child support. Man, you bitching and complaining and not realizing you dropping the ball when you choose not to verify an answer. If the defendant is a corporation, check this out. Let's just say straw man. The affidavit may be made by the president, vice president, superintendent, or any officer or agent who knows, keyword, who knows or whose official duty is to know about the matters set in the answer. Now, if you're the one that's receiving the child support summons, you're operating as an officer, as an agent, a type of agent to the Sesticate Trust. That's what the all caps name is. It's a business entity. Everybody knows by now, it's almost common knowledge that your name in all caps is a business entity. It's the name you use to conduct business. Whether you're buying grocery, whether you open up a bank account, you're using your social security number, you're getting to open up a bank account, to apply for a loan, to buy houses, to anything you do to conduct business is on your social security, on the social security card that was issued to you. That name is on it. Your driver's license, that name is on it, and it's in all caps. And it's for commercial purposes only. Okay, but you are the agent for that name. You were supposed to verify, to the best of your knowledge and belief, an affidavit to counter this affidavit that was filed into that court case. You're supposed to answer their affidavit. They swore under penalty of perjury. That's what it means to verify. We'll get to that in a second. You were supposed to do the same thing, and you didn't do that. You just showed up in court and started getting them check stubs. Okay? You started giving affidavits on how much money you make. Income. That's a commercial term. You operated as the I'm gonna say corporation. The fiction. You were operating as the fiction, as the Sestake Trust. That's an entity. It's a person. It's an artificial person. There are two different types of person. Keep in mind, in the commercial world, there are two types of persons. That's an artificial person and a natural person. You're operating as a natural person when you're dealing with these court cases. And the natural person, that's how they're going to see you, as the natural person, but you're supposed to control the name, which is the artificial person. The natural person is supposed to actually do the affidavit. Okay, so I'm just saying natural person, living man. You can use it interchangeably, or you don't have to. That's up to you. But I'm trying to explain this for clarity purposes. Okay, that's what you're supposed to do. Now you're supposed to verify an answer. Let's see, sworn affirmance as to an agent or authority or corporation officer to make an affidavit are not required. Georgia Laundry Company. These are case laws right here. Let's see. Say where a petition was not sworn to be true by a plaintiff, the defendant was not required to verify its plea by this section. Yep. So say a petition was not sworn to be true by a plaintiff. So their job as a petitioner, someone petitioning the court for some type of relief, they have to swear. Their petition has to be sworn. Otherwise, the defendant was not required to verify its plea. You're not required to do that if they didn't swear it. They had to. So anytime you receive a summons, it has to be verified. It has to be verified that sworn. That's what it means to verify. Matter of fact, let's go into that. Verification. Let's go back to this here. Verification. I'm gonna start right here. Petitions for restraining order, injunction, receiver, or other extraordinary equitable relief shall be verified positively by the petitioner or supported by satisfactory proofs. Or, that's the key word. If you're not going to verify it, you better have some evidence to prove what you just said. Okay? You got to either swear on the penalty of perjury that is to the facts that you stated in your petition, or you have attached to it supported. It needs to be supported by satisfactory proofs. Okay? When it comes to child support, I don't be trying to prove nothing to these people. I want them to shut the case down, because I'm not gonna get in there arguing about nothing. If there was some type of I'm gonna say complaint, saying I did this to a child, I did that, some type of abuse allegation, you wouldn't be in child support court. Your ass would be down. You'll be in criminal court, where they're trying to accuse you of something, and then they got to verify that claim too. So don't get into these arguments about, he left the child in the car by himself, or she left the child in the car, or she be smoking around the baby, smoking weed, and got dope boys in and out of her house. You ain't got no proof to verify that. If there's no proof to verify these claims and you're in child support court, you just rebut it with one statement and keep going. You ain't got it. They didn't verify it and they didn't prove it. So you don't have to get into these arguments when they do that, when people do that. So keep that in mind. Don't get in these emotional arguments. They have to verify, prove it. Okay. In all cases where a plaintiff file a pleading with an affidavit attached to the effect that the facts stated in the pleading are true to the best of his knowledge and belief, the defendant shall in like manner verify any answer. Say if the defendant is a corporation. I just read this one. Let me back up. That's not what I was trying to go to. Let's go to the next one. Verification answer. Here we go. Whenever an action is brought on an open account, and the same is verified by the plaintiff as provided by law, the answer either shall deny the either shall deny that the defendant is indebted in some. That the defendant is indebted in any sum, or shall specify the amount in which the defendant admits he may be indebted, and it shall be verified as required by law. Now, this is basically saying, if they did the same thing, say somebody saying you owe them some money, They got a petition. They send in saying an action brought on an open account. Say you got some type of light bill or some type of you owe a debt, some type of account where there's a debt that's supposed debt is owed, and the same is verified. And the same is verified by the plaintiff. I got a story to tell y'all about this one too, and it's a true story too. As provided by law, keep in mind they saying that you owe them something. They say if somebody this ain't child support. This is just any case. Okay, so if there's an account that's open, somebody saying you owe them some money or whatever, and they trying to bring you to court, or they send you a child support. I mean, not a child support, some type of summons to go to court, and they got a petition basically where they're trying to get released so they can get this account, this debt paid out, and they didn't verify it. Say if they verified it, if the plaintiff verified it under the facts of the debt or whatever of the petition, then you got to do the same thing. You got to verify your answer. They say the answer got to either deny the that you owe anything, or verify or speak on the amount or specify the amount that you actually do owe. And it says be verified as required by law. You got to verify your answer. Bottom line is it has to be verified. So say get y'all clear understanding. Verify. Legal definition. Y'all know I got a habit of saying is a declaration swearing that the statement made in a document is true. Depending on the jurisdiction, verifications are either made under oath or in the presence of a notary or a similarly authorized person. That's what verification means. Okay, so y'all see that's what it means. Well, as y'all see, I put verify and they got the same thing, but y'all get it. That's what it is. That's what it means to verify. Same thing you do in an affidavit. Okay, you got to swear it under penalty of perjury. You're swearing to the facts of the document of what you're saying, your answer. Okay, so now the story I had to tell y'all with that. There was a friend of mine who actually had she was kind of nervous about the situation when she got served a document where some company was trying to come at her for some debt that they claimed that she owed. Whether she owed it or not is irrelevant. Bottom line is they didn't prove it. They didn't prove it. They didn't verify their complaint. When you got a company that's giving you some type of summons, they're trying to say you owe them something. They don't have no agent that's going to swear under penalty of perjury. They're not going to verify it at all. They're just going to bring the charge against you, against your straw man, trying to see if they can get a claim trying to get a judgment against your name without verifying their complaint. So they didn't verify it. That goes back to the other thing where what was it that I said? That case law that I read. What was that case law that I read? Yeah. So where a petition was not sworn to be true by the plaintiff, the defendant was not required to verify his plea by this section. Same thing. I responded. She sent me a copy of that document, of that complaint, of that summons, and I responded, and I required them to prove it. Where's the contract? Where's the contract where I signed it and an agent of your company who represent your company signed, and where I supposed agreed to something to paying some type of debt, and they couldn't do it. They couldn't verify it, and so by them not verifying, we didn't have to verify nothing either. You know what I'm saying? So the case it went away. They tried it again like maybe 5 years later, and I did the exact same thing, and she ain't heard nothing from them no more. They realized they need to sit their ass down because they ain't got no way to verify. They can't verify the claim. If you can't verify it, because they don't want to put their neck on the line. If you swear on the penalty of perjury and you're lying and you found to be lying, then you can get in trouble for that. And companies know that they don't loan anybody anything. They never loan anybody anything. But anyway, that's another topic for another discussion. But bottom line is, when someone don't verify their complaint, then you don't have to verify your answer. Okay. But bottom line is, that's what always happens. When an action is brought in open, let's see, this is 112. Now let's go to 113. Here we go. All affidavits, petitions, answers, defenses, and other proceedings required to be verified or sworn under oath shall be held as sufficient, held to be sufficient. When the same are sworn to before a notary public, magistrate, judge of any court, or any other officer of the state or county where the oath is made, who is authorized by the laws thereof to administer oaths. The oath if made outside the state shall have the same force and effect as if it was made before an officer of this state authorized the same. Sorry about that. To administer the same. I was thinking that I had a brain freeze thinking about something at that time. Okay, but I'm gonna stop right there. This is what I wanted to I just wanted to read this part right here. Because a lot of people, I've heard people say that you can actually do an affidavit and just have three witnesses to sign it, and you don't need one of their notary publics. Y'all stop listening to people like that, okay? Because they got that shit from some damn well on the internet. I've heard people say that on the internet too. You try doing, think about it, why that doesn't work. And that's why this is actually sufficient right here. This is why this is sufficient right here. Number one, you could sign three different. I know people that can sign their different signatures in different ways, and it's the same person. And you can just create names. You can get any random people to sign something and swear something on the penalty of perjury, and there's nobody to be held accountable. You know what I'm saying? That's why you have people in place who is authorized to administer oaths. And they have them documented in their records. Who notified this? Who verified this for you? Who administered this oath? And we got somebody there who actually witnessed that oath, and they stamped their stamp on there, and they signed their name on there, confirming that they witnessed you signing this document. That's what makes this sufficient. You can't have some random people sign something and be like, and then there's no officer of the peace, which is a notary public, is also, and these are officers of the peace. A notary is also an officer of the peace. Let me see. See what it's gonna say. Georgia peace officer. Let's see. This is not what I was looking for, but that's not what I was looking for. I should have been looking in Black's Law. Black's Law actually shows you a whole list of them. Officer of the peace. Let me see. Officers of the peace. Anyway. Some jurisdiction. I was trying to find something out. That was a random move I'm trying to do, y'all. But if you look in, there's a list that I found. It was years ago. I did this years ago. I should have just looked it up before I hit record. But I don't want to waste up a lot of tape trying to do this. But anyway, I know a notary is an officer of the peace. These are, so I'm only highlighting the notary because these are the ones that we can easily access. They got them everywhere. They got them in banks. They got them here. Your next door neighbor might be a notary. You probably have friends and family that may be notaries. Some people don't use friend family because they don't think they can use them. I'll use anybody that's a notary. But I'll go to UPS. UPS stores have notaries, and I even use have witnesses. They even have you can even use their co-workers as witnesses if you got a document that needs two witnesses on there. I'll walk up in a UPS store in a heartbeat and be like, I need a notary and two witnesses, and I just pay the fee, and they'll notarize my stuff. So it's that simple. But you need bottom line is your affidavits, petitions, answers, defenses. They need to be answered, and they need to be sworn Okay, that's what you have to do. But most of y'all don't do that when y'all receive an opening. You know, you have to use that. You have to file an answer. The defendant shall always have the privilege of filing an answer under oath for the purpose of using the same as evidence in any motion to dissolve an injunction or to set aside any extraordinary processes or remedy granted. A sworn answer may be amended at any time by leave of the court as other proceedings, but in admission made in the answer may always be evidence. Shall always be evidence when offered by the other party. Okay, let me see. Man, hold on a second. I'm trying to see what I'm trying to do right here. Okay, but that's it though. I just wanted to kind of show y'all. You know, you have to put answers into these court cases. You can't just not answer, and your answer needs to be verified. You have a verified answer. If you don't file a verified answer in there, you just might get a default judgment against you. And let's see. I'm gonna read this one more time. A defendant shall always have the privilege of filing an answer under oath for the purpose of using the same as evidence on any motion. This is why y'all don't know why y'all don't want to use motions, but bottom line, that's another topic too. But motion to dissolve an injunction or set aside any extraordinary process or remedy granted. Okay, you could get that thing set aside. You can file your damn answer in that court case. A sworn answer may be amended at any time. May be amended at any time by leave of the court as other pleadings, but an admission made in the answer shall always be evidence. Shall always be evidence when offered by the other party. So this is what you have to do. You gotta answer that shit. If you don't answer, then they're gonna flow with exactly what they did. Admission by pleading. These supposed to be court. No. I was thinking that was admission by pleadings of peril contracts as preventing pleader from taking advantage of the statute of frauds. Okay, anyway, that's all I wanted to say, y'all. This video is long enough. I'm trying to shorten these videos up. I be having them 45 minutes long. This is 23 minutes. So I'm going to get on off here, y'all. I just had to make this video to show that you have to file an answer in the case. You cannot get served a child support order and not answer. If you don't file an answer in there, and make sure you look at my video where I speak on it's titled certificate of service, because at the bottom of your answer, it should accompany a page that has a certificate of service attached to it. Your answer needs to have a certificate of service attached to it. That's two different documents, but they're filed together as one. That's basically where you're showing is you're making a record that the other party, the opposing party, received a copy of your answer. So you take the original answer along with the certificate of service, you file it into the court case. You have extra copies when you file it, okay? Have extra copies of the certificate of service and the answer. Once you get it verified at UPS or wherever you get it verified, notarized or whatever, you make copies of it. You make copies of your certificate of service. Okay, look at the video on certificate of service. It's real simple. It's like a one sentence statement, and you got the address of the opposing parties. Okay, and you signing it. And you signing and dating it. That's all you're doing. But that's a certificate of service. You get that document, put it with your answer, and you take that. You make copies of them. Make 2 or 3 copies, and then you make sure that a copy of that goes to the opposing party. I send mine certified mail. That's what I do because I want to track it to make sure they got it. Okay, and it's also I put the certified mail number on the on the certificate of service document. Look at the video to see how I did that. But it's real simple. But that's what I do. You have to file an answer. Once you file an answer, when at the moment you file your answer, you have the clerk who you present it to file stamp your copies. That way you'll have your own record of that file stamped document, and you have a copy that goes to the opposing party that's file stamped as well. And when they receive it, they're gonna know that this has been filed into the court case because it has a file stamp on it. Okay, so now you can move forward. That is completing the process. That is answering the document. Now, if you want to show up in court, that's on you. But I'm gonna show up. That's how I can show up, because I'm brave enough to do that. Because I know what I'm doing at that point, and I'll understand on my paperwork. That's it. I ain't got nothing else to say but what's on that paperwork, on that answer, and that's it. And so I ain't gonna let them swindle me into no kind of conversation, no kind of emotional rants. If you scared that's what's gonna happen, you just file an answer, stay your ass home if that's what you want to do. That's totally up to you. I'll let you be the judge of that. But once you file an answer, there is no default judgment. Okay? But there we go. I'm out of here. I'm gonna get on off this video, and I'll see y'all in the next one. Emrose signing out.